A decision is expected soon from the U.S. Supreme Court that could change affirmative action as we know it. Our Arise News legal contributor is here today, Seema Iyer. She's going to explain what's at stake in this case as well as others. Always good to see you.
Always good to see you.
Okay, so this is what's going on. There's a ruling on Fisher versus University of Texas, right? That's expected in June, coming up very soon.
Any day now.
All right, coming up this week. Okay, now the case gives a question of whether colleges and universities can give preferential treatment to minorities in the admission process. So given the prevalence of race-based affirmative action programs in the country, why is this one being challenged now?
Well, let's look at the case itself. Now, the Supreme Court looks at cases if there's a law or something they have to challenge. So in 2003, there was a case that said universities, colleges can use race as a deciding factor. Now, what University of Texas does is incredibly interesting because they take in every single high school, the top 10%, merit-based. Now, if you're outside of that 10%, like the young Ms. Fisher was, then you may have an issue. Race is a factor, but as well as your grades, your extracurricular activities, your personal statement, charitable activities, this all comes into play. Now, why is this in front of the Supreme Court? Because Ms. Fisher has gotten it so far where the lower courts have said, you know what? We still support affirmative action, but because of this 2003 case, it's getting pushed and asked the Supreme Court, let's look at the 2003 case. Are we going to uphold that case and allow this college to continue?
Based on the argument that she's making, Seema, what do you think the chances are of this case?
You know, what troubles me is that the University of Texas is doing this, merit-based acceptance. So my position is, well, they are accepting people on merit. So why is, what is wrong with the affirmative action and trying to help underrepresented people? The opposing argument is saying because Texas has a huge Latino population, it's 38%, and I believe 12% Black population. Because they accept that top 10%, they're getting that racial diverse profile at the University of Texas. So it's a kind of confounding argument, but they're saying, wait a minute, University of Texas, you have enough diversity. You have all the races and ethnicities balanced. You don't need to also include this in your factor in deciding outside the 10%.
Isn't it an uphill battle, though, since there's already been a ruling about this allowing the affirmative action, the guidelines in affirmative action?
Yes, most law professors around the country are saying it's going to be a split vote. And Justice Kagan has pulled out of it. I'm not sure the reason, but she's not voting on this. So it looks like it could be a split, like right down the middle, 4-4.
And what happens then?
And what happens then, they will probably, again, move to re-argue. The attorneys would...
They would just bring it back.
They would try to bring it back, yes.
Very interesting. Okay, we'll keep our eye on that, and that'll be coming up in the next week or so. Let's move on to another very interesting case. We've been talking about it for the last couple of weeks or so, and that is, of course, the IRS scandal. And Lois Lerner went before the committee and basically said, I invoke my right, my Fifth Amendment right, not to testify. However, before I do that, let me make a statement.
Right, exactly. And everyone in Washington, and actually even in New York, I mean, it's just such an interesting issue when she had this statement like, I didn't do anything wrong, I didn't lie, and then I invoke my Fifth Amendment. So here's why it's so interesting is the Fifth Amendment, it protects a lot of things. It's part of the Bill of Rights and the Constitution. But in this case, it protects statements. And there's everything from statements we make in court, civil, criminal, statements you make in a deposition, and statements like we know Miranda. Miranda is part of the Fifth Amendment. What Lois Lerner did in this situation is that what we call she opened the door by making a statement. So, Debbie, if I open the door, you're allowed to walk through, which means that you are allowed to question me about what I just stated. So, and then she tries to shut the door. Now, in a criminal proceeding, this would probably not be allowed. She would have effectively waived her privilege.
And be compelled to testify.
Right, exactly. Where this congressional hearing is considered a civil proceeding.
Okay.
And the rules are less flexible, less stringent. So in that case, perhaps she will be allowed. She's probably going to get called back quite soon because the
And I think they
investigation-
said they reserve the right to call her back. But did an attorney advise her to do this? Do you think she went off the reservation?
I'm so glad you brought this up because I forgot. I was like, who's that person behind her? That's her lawyer.
Oh, yeah.
And so why isn't, see, again, whether it's, if I am in traffic court with a client, I will say, do not say anything, don't speak, because why put yourself at risk by opening that door? Because if you testify in Congress in a civil proceeding, that testimony can be taken and held against you in a criminal proceeding.
Mm-hmm.
So I am shocked that that attorney allowed her to make any statement whatsoever.
It does seem shocking, and I wonder if, you know, I know how you attorneys can be. You know, that if she doesn't if she doesn't follow the advice, then, you know, some attorneys say, well, then I can't properly represent you if you're not going to follow the advice. So I wonder if you'll see a switch in her.
The alternative is also that she just went off script.
Yeah.
She could have just opened her mouth and said whatever she wanted to say. People do that.
Yeah, but I think she wanted her cake and eat it too. She wanted to say what she had to say, but then she didn't want to say anything more.
So everybody else does, and you can't do that.
Yeah.
You just can't do that. You're putting yourself in so much danger. This is the rest of her personal and professional life that's at stake.
Indeed, indeed. We'll see how soon she's back before the committee on that. Okay, so let's move on to the Jodi Arias trial. The jury deliberated to decide upon her fate and couldn't decide.
They couldn't decide.
So what happens now?
They deliberated for about 13 and a half hours. Now, this is the penalty phase, which is the third phase of the process in Arizona. That's how it works. They are rescheduled for July 18th. Now, they will get another jury, brand new jury. The jury will already have known that she'd been convicted of murder in the first degree, and they will know about the findings of extreme cruelty from the second phase. All they have to decide is death penalty. You only get 2 bites of this apple, Debbie, and if they cannot reach a unanimous verdict, it's over. Then the judge decides whether to sentence her to either life with parole or life without parole. That's it.
Oh, okay. So what's the chances of a second jury being able to come to a unanimous decision if this jury couldn't?
I think you have to look back at historically what's been going on in our country, and in the past 100 years, only 40 women have been put to death. And currently, if you look at death row inmates, only 2% are women. So I think if you look at those statistics, it tells you that she's probably not going to get the death penalty. For some reason, people have a harder time sentencing a woman to death as opposed to a man. I do not understand why, but it's something called the chivalry syndrome,
Well,
actually.
especially considering the heinousness of this crime. It was a pretty brutal crime in this case.
And they actually found that she was extremely cruel in an hour and a half.
Isn't that interesting? So interesting. I wonder, does it have anything to do with the statements that she made to the press? You know, first she said, I want to be put to death. I don't want to go through this. No, I want to live. Does that play into it?
I do believe that some jurors or some people in that pool of potential jurors may have succumbed to her attempts at reverse psychology, which is what I think that was.
Very, very interesting. All right, Seema Iyer, thank you so much.
Thank you.
Appreciate it. We'll see you again soon.